Good evening. Hi, hi.
Good evening, Sehen.
How are you guys? How was your week? So I think now it's getting almost 17. So let's start with the people we have. What do you think, Abagoza?
Yes, we can start with the people that we have. Others will join us along the way. And also the session is being streamed. So those that miss out on the live session, they'll be able to catch it on YouTube.
Okay then. So let's say hi to Emmanuel. Emmanuel, how you doing? Welcome.
Hello, how are you doing? I hope I'm loud and clear.
Yeah. Sure. Okay. So Emmanuel, thanks for having you. We are so glad that you are you are taking us to lead this session today. So, hi everyone, hello Film Chat families. So today we are having a very happy to welcome to Wanyama Emmanuel Bright. Am I saying your name correct?
Yes, it's Wanyama.
Wanyama. Okay, I'm Ethiopian, so don't take to me wrong.
No, it's okay.
Okay, so he's our guest speaker today. So, from the knowledge I have, Bright is an advocate of High Court of Uganda. He works in areas like technology, media, communication, and intellectual properties. So he helps creators, filmmakers, artists, and companies project their ideas, their content, and their brand. So he also knows works in sustainability and carbon markets, helping Uganda build strong laws for climate and environmental protection. He has written and spoken about Uganda's new climate rules and how they can help the country grow in positive ways. Also, Bright is not only a lawyer, he is also a spoken word poet and writer, which makes him understand the creative world even better. So he has taken part in big events like East African Carbon Markets Forum and Kampala International Theatre Festival, speaking about the importance of protecting creative works, especially for playwrights and other artists. So today he is here to teach us about intellectual property, how creatives can protect their ideas, their contents, and their vision. Usually we call it intellectual property as an IP. It's a short form of to say intellectual property. So thank you, Emmanuel, for being with us today. I hope we are going to get a lot from you. We are so ready to drink all information that you have. I think it's hot, right?
Surely is. Yes.
Okay. Thank you, Manuel. So before I give you the stage, I think we have to pray. So who can lead us with the word of God? Can I say Samuel? Are you ready like to lead us on prayer? I just picked your name. It's so simple to call it Samuel Xavier Kizito.
Yeah, thank you. Yeah, because it's a beautiful name in the Bible. So, yeah.
Okay,
Well,
lead us, please.
yeah, it's my first time coming since we shifted to Zoom, so it's really an honor to be here. Great topic of the day. So let me usher all us into the house of the Lord. Dear God, thank you for today. Thank you for this evening. May you open our minds, open our hearts, open our souls as we go through this session of the day. May you bless us. May you give us the energy to absorb and learn from today's session. May we use the knowledge that we shall get from here to impact the world with our creative works. May we learn how to protect ourselves as creatives. And may you bless our facilitator for the day. May you use him as an instrument of wisdom, personal knowledge to us. Bless us all through this session. Amen.
Amen, amen, amen. So I'm giving you the stage, Emmanuel. Take us through your session.
Okay, thank you. Thank you very much. I'd like to thank you for inviting me for this session and to talk about something that's very dear to my heart, which is intellectual property. I think what I can say is, as an artist, I think this must have been in undergrad when I had my first anthology published. And I just got to understand that getting your work from the stage of an idea into a complete work and publishing it is not an easy process. And through that process, I got to learn about intellectual property, what intellectual property means to me as an artist, and hopefully I can be able to share a bit about that with you today. Your platform is focused on film and indie filmmakers, and so I will try through my presentation to tailor it to that, but also just give you a general outlook on intellectual property, what that looks like. Yeah, so I've not prepared a presentation. I can have a presentation shared after the session, but I will just walk you through what I'm going to talk about, and then, yeah, we can get into it. So I'm going to talk about intellectual property rights, what every creative should know in respect to intellectual property rights. And then I'm going to juxtapose or compare film and intellectual property. And then also briefly talk about AI and intellectual property and what that looks like. And then I think the most important aspect of our discussion is contracts and agreements. As an artist, what are the considerations that you should have at the back of your mind before you take part in a creative project? If there is a contract of any sort, what are you looking at? What should be included in that contract? So that's essentially going to be the flow of the discussion. So yeah, I think let's get in. So when talking about intellectual property is essentially something that you have created. So something that you had, it was an idea, and you put it into a tangible form. So one important aspect is intellectual property cannot protect something that is still an idea. That idea has to be reduced into material form. It could be on paper, it could be in a PDF, a Word document, but you have to put it into a material form for it to be protected. So for a film, say if you have this script that you've been thinking about for very long, you've never executed, you've never done anything, and then someone else does the exact same thing, you cannot come up and say, oh, this person is doing what I envisioned or what I thought I would do. Yeah, so the essential idea is that without you reducing it into material form, you cannot get protection from it. So what I'm going to do is just take you through a brief discussion on what intellectual property is, what are the rights therein, what it entails, mainly for artists, and then just go through what I discussed, and then we can have a Q&A session at the end in case there is anything that I say that doesn't make sense or that you have questions about. We can have a session at the end. I think that's a fair way for us to proceed. Unless there are any objections to that, I can start my discussion. So I think I can start, right? Okay.
Yes.
Sure. Okay. So let me get started. So when we talk about intellectual property, what we're looking at is a whole suite of intellectual property rights. You're looking at copyright, you're looking at trademarks, you're looking at let me see, you're looking at patents, you're looking at, so patents, you're looking at industrial indications, geographical indications, and the like. And so for our discussion today, I'm particularly going to look at copyright, because copyright is the aspect of intellectual property that directly affects artists. And then I will also talk briefly about trademarks, what those are, how you can protect those, and then, yeah, just talk about the different intellectual property rights that come up when you are dealing with film. So for the purposes of the discussion, I'm going to speak in detail about copyright, because copyright is the primary intellectual property right that affects artists, right? And mainly the artists that are present for the discussion today. So yeah, so what is a copyright? So a copyright is a right to commercially exploit works through selling copies of work and licensing and assigning that work. So if, say, you come up with a play, a script of a play, right? What happens is that play can then be produced, and then you can have like a movie from that particular play. But the right in there is in the phrase copyright, that you have the right to copy that particular piece of work. And so any other individual does not have a right to copy that information without either your approval or your consent. And so that is the guiding idea behind copyright, and that's really the main premise on which copyright exists. So a copyright owner has the exclusive rights to do acts in relation to the work, make copies, broadcast that work, or selling copies to the public. So in Uganda, we have the Copyright and Neighboring Rights Act, and that is the main law that regulates intellectual property rights in Uganda. And mainly copyright, which is going to be the main basis for our discussion today. We have international treaties that we are part of, and which also operationalize copyright and intellectual property rights in Uganda. One of them being the Berne Convention for Protection of Literary and Artistic Works, and then the TRIPS agreement, which is the agreement on trade-related aspects of intellectual property rights. So this and a couple others, the Marrakesh Treaty, etc. So these are some of the treaties that have been ratified. Ratified meaning Uganda is a party to these treaties and has then gone ahead to localize these treaties into our local law. And so it has gone through that whole process, and so that's how these particular treaties are now enforced or applying in Uganda, right? So when we look at the elements of copyright, we're looking at originality. So what the work that you have come up with doesn't have to be new or innovative, but it has to be a matter, but what we look at is the manner of creation, and what we're looking at is, where does this particular work originate from the author? So if you are an author, were you the one that wrote the script? So we're not looking at originality or in novelty, in the sense that what you are coming up with has to be new and no one in the world has ever come up with that idea. The idea is it something you have thought about, and is it something that you have reduced into writing? Yeah. And so by you doing that, you then get the right to use this particular work, or charge anyone in case they want to make copies of this work, or in case they want to use this particular piece of work. So under the examples of protected works, we're looking at literary works. So here we're looking at drama or music or work which is written, which includes a table or a compilation of computer programs and databases. So like I said, if you come up with something and you put it on paper, you already have a copyright for it, right? If you come up with a document on your laptop, put it in Word, save it, you already have the copyright in that particular work. You own that particular work. I think the caveat, however, or the exception that I will mention is that tomorrow, for enforceability, it would make sense for you to go ahead and register that work. Because when you register that work with URSB, Uganda Registration Services Bureau, you're now able to enforce any infringement on that work. So the registration is a matter of just you doing your part, prudence. And also in the event that you want to enforce any copyright infringement, yes, so we're looking at literary works. So a second example is dramatic work. So works of dance and mime, and this work must be recorded for copyright to exist. And then we're also looking at musical work. So words or actions intended to be sung, spoken, or performed with music. And so when you look at musical work, there are two rights inherent in musical works. Those rights being the rights to the words, so the lyrics to the music, and then also the musical notes themselves. So how the music has been manifested. It could be through you having a guitar and a couple other instruments, and so that melody, you have a copyright to that. So both the words and also the musical notes and the musical manifestation of your work. Then third, we're looking at artistic work. This is graphic works, photography, sculpture, architectural works, building models, or the building itself, and then work for artistic craftsmanship like jewelry, like furniture. Then we're looking at architectural work, which I talked about earlier. So if you have a plan for a building or the building itself, you have a copyright inherent there. And so next, where another manifestation of copyright or form of copyright or work that can actually be protected is sound recordings, films, and broadcasts. So these are derivative works based on already existing and original literary, dramatic, and musical artistic work. So when I talk about derivative work, that's a new concept. And so I'll just go ahead and explain what that is. So a derivative work is work resulting from adaptation, translation, or any other transformation of an original work, but which constitutes an independent aspect of it. So a derivative work is, say, we've talked about all these different pieces of work. We've talked about the dramatic work, the musical work, artistic work, literary work. And so in most cases, derivative work is a confluence, or let's say when you bring all this together, right? And so an example of derivative work could be a remix of a song. You have the initial song that was composed by, say, the artist who wrote the lyrics and performed that particular song, but then you can have a remix or you can have like a cover. And so that, in most cases, is derivative work, and that also attracts intellectual property protection. So someone can have that protected. But I think what is important to mention in respect to derivative work is the intellectual property right in respect to the first work that was created still exists, but you have to exercise a certain level of effort, a certain level of time, a certain level of skill in producing this new work. And this new work should not just be a copy of the first work. It should be something that manifests those elements, like I said, skill, time, effort. And so through that, you can have, let's say, a cover, or you can have a remix of a particular song. And so that particular remix is also subject to protection under Ugandan law. So the work should be significantly different from the original work, and then subject to copyright of its own, which is what I've just explained. And the qualities of copyright must be present. Like I said, you need to have a particular skill that you've exercised in that process. You need to have given it time and effort to come up with this particular derivative work. So I think that is an apt description of derivative work. Like I said, if you have any questions, we can get into them at at the end of the session. But if you feel like it's burning, you can definitely put up your hand and I can explain that particular aspect better or more. So another type of work that is protected is typographical arrangements and published editions. So this could be books, this could be encyclopedia, stuff like that. And so now the next step that we're looking at is the difference between authorship and ownership. That authorship and ownership are two distinct aspects. And so I'm going to go into explaining what those particular aspects are. But like I started at the beginning, I explained that for copyright to subsist, for an intellectual property right to subsist, you have to have got the idea, and that idea has to have been manifested into material form. You reduce it into writing, you probably took a photograph, you probably recorded that video, recorded that sound, whatever it is. So what is important is within the copyright, there are also additional rights that exist. And so these rights are the rights that can be then exercised by the artists. One of them being the moral rights, and then the second being the economic rights. So in a nutshell, I'm going to go into detail to explain what those are. But what moral rights are essentially, if you create a particular piece of work, every time that work is used, you have to be recognized for that work. So that's why when you're watching, say, a music video, you always see the name of the artist at the bottom. Or if you're reading a book, you'll see the name of the artist at the top of the book. So those are your moral rights as an artist. The economic rights are essentially the right to obtain an economic benefit from this particular piece of work. Yeah. So for our discussion, I think our discussion is going to be premised mainly on the economic rights, because what we are trying to understand as artists is I have come up with this particular piece of work, I have put it into tangible form, and I want to put it out into the world. But beyond putting it out into the world, I'm also looking at how then can I protect this work? And how then can I go ahead and be able to earn something from the work that I've created, right? And so that's going to be the discussion that we're having. So I talked about authorship and ownership. And so I'm just going to compare those two and differentiate them and just explain to you how authorship is separate from ownership. So authorship is essentially the person, authorship or the author is essentially the person who creates the work or commissions the creation of the work. So the person who creates the work, like I explained, you have a particular poem, script, whatever it is, you put it into writing, you register it, you are the author of that work. But then the other aspect that I talked about is the person who commissions the creation of the work. So a good example I could give is, say, you are an artist and you are, let's say, you make documentaries, etc. So an organization approaches you and says, hello, we see your work, we see what you do, we would like you to make a documentary for us. So in that particular aspect, if you have had that discussion, you have an agreement, they have paid you to create that work, then they actually own that work. They actually own the copyright to that work because they commissioned you to do that particular work. So I hope that distinction is clear, that you personally can be an author, but also there are instances when you are commissioned by a third party. And so when that third party commissions you and you are creating that work solely on the orders and on the payment or action of that person's direction, then that is commissioned work and they ultimately own the intellectual property rights to that work. So the originator of information may not be considered the author. And so that's what I'm also trying to explain. So a person making a speech. So there are instances when even if you are the one who has created something, you are also not the author. So I think the first one I explained is commissioned work, where you create the work based on someone's directive and someone has remunerated you, paid you to do a particular piece of work. The second aspect is if, say, you are making a public speech and someone makes a report, say a reporter, a news reporter writes an article about your speech. In most cases, they own the copyright to that particular piece of work that they have created. So regardless of the fact that you made the speech, they went ahead and created this particular work and spent time, put effort, and put some skill into creating that report or article. And so since they have done that, then they actually own the copyright to that particular report or article. And so regardless of the fact that you made the speech, they own that work. And so I think what is important to understand and what is going to keep coming up is for you to own the copyright or own the intellectual property rights in any particular work, you have to spend time, skill, effort in creating that work. And so if you have done the above, then you actually own the copyright to that work. And so this is also an instance where if someone, a news reporter wrote an article based on your speech, they own the copyright to that particular article that they have created. And I hope that distinction is very clear. So due to the effort, skill, and time spent, that makes the new work, so the new work being the article, an original piece of work, and then they, by implication, own the copyright to that work. And so this particular principle cuts through all the different pieces of work, so of intellectual property. So like I said, my discussion is premised mainly on copyright because copyright is what directly affects the artists that are attending this particular session. But the other intellectual property rights, like the trademarks, like patents, like geographical indications, some of which I'm going to talk about during this discussion and help you understand what those are and how they can be differentiated from copyright, right? So a dictation or a writing verbatim of a person's, say, speech, does not then give you a copyright. So I think it's important to make this distinction that if a reporter listens to your speech, writes an article based off of your speech, they have the copyright to that particular piece of work that they've created. But if, say, during this session, there is someone who is writing word for word everything that I have said, and then they transcribe that everything that I have said, they have no copyright to that because they have not spent any effort, skill, and time to create something new from what I'm saying. So I hope that distinction is clear, and it will be important moving forward, because if, say, tomorrow you have a particular piece of work and you have to go to court to enforce your rights, these are some of the questions that are going to arise. And so, yeah, that is very important. So there are also aspects of joint ownership where you have multiple artists that are taking part in the creation. So this could be a song and you have multiple songwriters. And so each of them has spent the effort, skill, and time in creating this particular piece of work, which is the song, or writing the lyrics to the song. And so they co-own that work, and they own that work in equal parts, because you cannot split the song into, let's say, 4 parts. And so the work exists in itself, and so they co-own that work equally amongst themselves. So in the event someone wanted to use that piece of work, they will need to get the authorization from each of the owners in that particular piece of work. So that is the main aspect in respect to authorship, that in some cases you can be the author and not the owner. And I think I went ahead and described that. If a reporter goes ahead and writes an article based on a speech that I've made. So if, say, someone writes an article based on this discussion that we're having, they would have the copyright to that particular article, right? But if someone just transcribed what I'm saying and just put it into writing and did not change anything, and it's exactly word for word what I've said, they might be the author of that particular transcribed piece of work, but they are not the owner of that particular piece of work. I am the owner of that work. And the reason why that is because they have not put in a particular amount of effort, skill, and time to make that work, and it would not be regarded as original work, because that's the main yardstick for you to have the right, the intellectual property right in the work. And so let me talk a bit about ownership. Oh yeah, sure. Like I said, if you have a question, please do go ahead and ask the question in real time, in case it is something that you feel like you would want to know. So when we're looking at ownership, ownership is the first owner of the copyright. So like I said, if let's say I wrote a particular poem, I am the author of that particular poem. And so I hope that distinction between authorship and ownership is clear. Authorship is, are you the one that created the work? Are you the one that, let's say, made the speech? Are you the one who wrote the particular thing? But then ownership is distinct from authorship, and the instances in which one can be an owner and not an author. Yeah. And those instances, like I explained, is through commissioned work. We're all artists here. Someone pays you to do a particular piece of work. That particular piece of work is not, you will be the author, but not the owner of that particular work, because the person who commissioned you actually owns that particular piece of work. And so when we're looking at commissioned work, which is something I've been talking about for a while, there are a couple of considerations that we shall look at. So commissioned work can be something that is created while you're employed. So if, say, you're an artist and you're attached to, like, let's say, a record label, or you're attached to any organization that creates work based on what you do, then in most cases, the work that you create while an employee in that particular organization is not your work, it's the work of the organization. And that's one example of commissioned work. So some of the considerations that will be looked at is, did you create this work during the working hours? So if your working hours are 9 to 5, did you create this work between 9 to 5? And so in most cases, if you created the work between 9 to 5, that is commissioned work, because your employer has created the environment and is the reason that you have created that work. And you have created that work while you were employed, right? And then works in his own time, but produces the work using the employer's facilities. So say you stay at work longer beyond 5 p.m., right? But you're using the work laptop, you're using the work Wi-Fi, you're using all the equipment that has been provided by your employer. In most cases, that work is actually commissioned work and does not qualify to be your work. And so even if you also create work, so let's say you are attached to a photography company, right? And that's what you do. But then you also have another skill of, say, poetry. But there are instances in which that poetry that you create can actually be commissioned work, even if it's not in your direct job description. And like I said, some of the considerations are, did you create this during the working hours? Did you create this using the facilities or equipment provided by your employer? And so that is essentially what commissioned work is, yeah. And so I think that gives you a clear idea on what commissioned work is and how that would arise, right? So during your economic dealing. So like I mentioned, you have the moral rights and the economic rights. So during the economic dealing with your work, right, there are particular economic rights that that subsist in the work. And so the economic rights that subsist in the work are, let me just find them here so that I can read them for you. Yeah, so the economic rights that exist in the work are, first of all, to publish, produce, and reproduce the work. So if you've come up with a particular piece of work, your economic rights and your rights to that particular work subsist in you being able to publish this work, produce it, and reproduce that work, or copy that work. Distribute or make available to the public the original copies of the work through the sale or other means of transfer of the ownership, right? So you can license this work, assign it to someone else. Those are important concepts, and we shall get a bit into detail just to understand what assignment and licensing means. So to perform the work in public, that's also another right that you have. To broadcast the work, to communicate the work to the public by wire or wireless means, or through any known means, say the internet or any other medium of your choosing. Where the work is a pre-existing work to make a derivative work. So like I said, you have the original song, and then you have, say, a remix of that song or a cover of that song. You have the right as the artist to create a derivative work from that initial piece of work. So to commercially rent or sell the original copies of the work, to do in relation to that work any act known or to be known in the future. So your rights to that work are many, and they are non-restrictive. And so to produce transcription into Braille, which is accessible to blind persons. So that's another thing, that you can have a particular piece of work, and that particular piece of work can be translated into Braille. And so when it's translated into Braille, it can then be available to people who can't see to actually use that particular piece of work. So yeah, those are the economic rights in the work. I think now it's important for us to talk about the moral rights. So like I said, in any particular piece of work, you have both the moral and economic rights. And so we have gone into detail regarding the economic rights in the work. Now we're looking at the moral rights. And what I explained initially is the moral right in the work is essentially, if you create a particular piece of work, you have to be identified anytime that work is used or anytime that work is performed, right? And so that's the main premise, or that's the main manifestation of your moral right in the work. So your moral right is the right to claim authorship or performance of that particular work. So one way that moral rights manifest is you can be identified as the author to the work. You can object to the derogatory treatment of the work. So that's your integrity right. So if you come up with a particular song and someone is mischaracterizing your song or misinterpreting your song or performing it in a way that does not align with your initial vision for that particular piece of work, you can actually stop them from doing that because you have the moral right to that work. So to falsely attribute work to you. So in the event you come up with a particular piece of work, or in the event anyone falsely attributes work to you, or work that you do not feel is your work, then you can easily exercise your moral right and ask them not to attribute that particular piece of work to you. And then the right, and then I think another right that comes up is the right to privacy. So this right to privacy is in regards to photography, films, and private and domestic purposes. So when you're looking at the right to privacy, one of the ways that this manifests is through your image rights. Yeah, I'm going to go into detail and talk about that. But say you go to a party or you go to an event, they take your picture, and the next thing you know, when they're advertising the next, say, installation of that event, you're on a bunch of billboards in Kampala. Your consent was not received, but these particular people are going to derive economic benefit from this. So you can actually sue them because they are, let's say, derogating or taking away your right to privacy. And so they have to get your consent. And if there is any economic benefit that is derived, you have to be able to benefit also from that particular piece of work. So, yes. So there are some exceptions to your intellectual property rights. And so I think I'll just go into those. So it depends. So one of those is the type of work. So if you're looking at, say, computer programs, in the production of a computer program, there are so many people that are involved in that process. And because there's so many people involved in that process, you can't have all their names, let's say, attributed to that particular piece of work. So this is an instance that your, let's say, moral rights might not be enforced, right? But all these have like exceptions. They're not set in stone. So there are instances of fair dealing if, say, someone uses a small percentage of your work, right? And so because they use a small percentage of your work and not the whole of your work, and if they're using it, say, to criticize your work or for educational purposes, that can also be an exception to your moral rights. So incidental inclusion of your work. So if someone by mistake uses your work, but they're not using a very substantial amount of your work. So let's say if it's a song, they're using like 2 seconds or 1 second of your like 4-minute song. In most cases, you might not be able to enforce your intellectual property rights in that particular song, but this is also judged from a case-to-case basis. And so I think that would be important for you to note. So if it's also for educational purposes, if someone is using your work for educational purposes, that also is an instance when you might not be able to enforce your economic or moral rights. But I think the underlying aspect that we have to understand is, and this is one of the considerations that court will look at, is this person or are these people deriving economic benefit from your work? So even if they are doing all these things and they're deriving economic benefit from your work, then you, in essence, can actually enforce your intellectual property right. So I think it's important for me to mention that. Another exception is through parliamentary or judicial proceedings. So if your work comes up in a particular judicial proceeding or parliamentary proceeding in the plenary, you cannot enforce your intellectual property rights in that particular aspect. And then also in the event you have given them permission to use your work. So if you have given them permission and consented to the use of your work, you can then come up and claim that, oh, you're using my work without my permission, or you have infringed my intellectual property rights or copyright. You gave the permission for them to do that. And so in the event that you have done that, then you cannot then come and, let's say, insert a suit in court claiming that this person has infringed your rights. So yeah, so I think I had briefly talked about the right to privacy. And so now I'm going to talk about the right to privacy in detail. So the right to privacy comes up in relation to your image rights, right? And so this can be in photos, in films, and because of the power of visual media. And so say you are at a party or whatever, and someone takes your picture, right? And so they are taking it for their private use. But in the event you find out that later they are using this particular picture and deriving economic benefit from that particular picture, then you can actually sue them for derogating your right to privacy, or breach of your right to privacy, or breach of your image rights. And so a particular example I can give, there was a case back in the day where there was a wedding photographer who had been commissioned by a family to take pictures of like whoever was getting married. And so what then happened was the dad to, I think, either the bride or the groom passed on, and passed on in quite a gruesome way. And this got public attention. And because it got public attention, there were a couple of news articles that were run in relation to the father, to, I think, either the bride or the groom. And so this particular photographer who had been commissioned by the family used some of those photos and shared them with this, I think, either newspaper outlet. And so what happened is they paid him for that particular piece, for those pictures. And because they paid him for those pictures, the bride and groom were able to take him to court and sue him for breach of privacy. And yeah, the court essentially held that he had derogated or breached his right to privacy, and also subject to the fact that he was deriving economic benefit from these photos that he had been commissioned to create. He was also breaching their intellectual property rights or copyright, right? And so I think that is like an apt description of the right to privacy. So the rights of copyright owners, like I said, is to copy the work, to issue copies of the work, to rent or lend the work to the public, to perform or show the work to the public, to broadcast the work, or to make an adaptation of the work. So initially, I told you about the overarching or the guiding law in this particular area, which is the Copyright and Neighboring Rights Act. So for the past, say, 30 minutes, I've been talking about the copyright aspect. Now, let's talk about the neighboring rights. So neighboring rights are manifest in 3 categories. And so this is through performing artists, so producers of sound recordings, and broadcasting companies. So the best way that I can explain neighboring rights is if you have a particular a song, say, and you have created that song, there are a bunch of intellectual property rights that exist in that song. I think I had talked about the fact that you have the words, the lyrics to the song. So that's one thing that attracts intellectual property protection. And then beyond that, you're looking at the melody, right? So that particular melody that is created. So this melody could be through a guitar or a piano, whichever you choose to use. That also attracts intellectual property rights. But in the process, you also have the person who is going to perform the song. So in most cases, the person performing the song is different from the person who wrote the song. There are instances in which that is possible, where you have a songwriter who is different from the actual person performing the song. And so in this particular instance, that person who performs the song also has rights to that song, right? And so that is a neighboring right that is inherent in that song. And then you have the producer. So the producer is the person who puts everything together and stitches the song together. The producer also has rights set to the sound recordings, right? And then you have the broadcasting company. So the broadcasting company could be, let's say, it could be like a television station, or it could be like the company under which all this is being created, like a production label, let's say like Swang's Avenue. They also have a right in that particular piece of work. And so those are examples of neighboring rights. And so what you need to understand is for copyright, there are particular neighboring rights that are inherent in the copyright, right? Or in that particular piece of work. So it's not just the person who created the work. There's co-authors, like I said, all these different people who have participated, and each of these people has a right in the work. So that could be the producer, that could be the performer, that could be the songwriter or the person, say, playing the guitar, piano, whatever, all that. All those people have particular rights in that work. So I think I talked a bit about image rights or personality rights. And so this is the right of an individual to control the commercial use of his or her name, image, likeness, or other unequivocal aspects of one's identity. So beyond your image rights, you're looking at someone using your name. And so if someone is using your name without your consent, you can actually be able to sue them in this particular regard. And so that is where the image and personality rights come in. So every individual has a right to control how his or her person is commercialized by third parties. So if they are using your picture to promote a particular item, say a beer or a soda or whatever, they did not get your consent, someone just took your picture while you're in public at some point, and they're deriving economic benefit, they didn't get your consent, you can actually sue them for a breach of your economic rights. And that's why I think if you pay attention, you'll notice that in most cases, when you go for events, you have like a form that you fill in. It's in most cases a registration form. And in that form, there is a particular part that asks you for permission. Like, are you okay with us taking your pictures and reproducing or using these pictures in the future? And so if you tick yes, then you have given them the consent to do that. And so that's a particular aspect when you cannot be able to enforce your image rights or personality rights. So those are some of the considerations you have to look at when, let's say, you go to an event and you're ticking yes. You're ticking yes there. That is the implication of that. Yeah. So these rights include the right against publicity, so the right to keep one's image and likeness from being commercialized, exploited without their permission, the right to privacy or the right to be left alone and not have one's personality represented publicly without their permission, and copyright supersedes the right in the event of consent. And that's what I was trying to explain, that if you give someone the right to use your, say, image or to use your likeness and you give them that consent, then you cannot enforce your image rights or personality rights in the future, right? And so an example is there's a Ugandan case, it's called Asegewini versus Opportunity Bank. What happened is this individual, Asegewini, Opportunity Bank was promoting one of its products. And so it used her picture to promote this particular product. And so her picture was on a bunch of billboards. And so she finds out from third parties, I think people known to her, that, hey, we saw your face on this particular billboard. Opportunity Bank is advertising one of their financial products. And she had not got her consent. Opportunity Bank had not got her consent to do this. And so because of that, she was able to sue Opportunity Bank, and court held that Opportunity Bank had breached her personality rights and her right to her likeness being used in public. And so that's an example of how this can manifest. And so some of the considerations that are used by court in the event you want to enforce your rights is, are you identifiable? So in the event, in those billboards, there's like your silhouette or your shadow, and it's not really you, but you have to like explain that, no, but that's the shape of my head. In most cases, you will not be able to succeed. It needs to be clear that you are the actual person that appeared in that billboard or in that advert and the like, and the action was intentional. So you need to demonstrate that in this case, Opportunity Bank intentionally used your picture or your likeness in their advert, and they're obtaining economic benefit. And that's the third one, that the defendant acted for the purposes of commercial purposes. And so Opportunity Bank was advertising one of its products and was definitely going to derive economic benefit from the advertisement of that product. And so what you're looking at is, are you identifiable? Is that clear? Can someone be able to identify that that is you. So if it's Wanyama Emmanuel, there won't be many questions as to you being the one that has been advertised. So that has to be clear. The second is it had to have been intentional. Yeah, and your consent was not obtained. And then the third is that they are deriving economic benefit. And so I have painstakingly taken you through what intellectual property rights are, moral rights and economic rights, and just taken you through just an overarching or meta view of what copyright and intellectual property rights are. And so now let me just talk about the infringement. So do we have any questions at this point? I might continue and people have questions. Do we have any questions at this point?
I had one question,
Oh,
and
sure.
I think it was more on licensing, and it's what licensing terms do you think filmmakers ignore and end up regretting in the long run?
Sure. So I'm going to talk about this when talking about contracts and agreements. And so what I was looking at is talking about the intellectual property rights first and what every artist or creative should know about intellectual property rights. And then I'm going to talk about film and IP, how the two intersect, what particular intellectual property rights exist in film and IP. And then I'm going to talk about AI and IP. There are a couple of considerations there, and then talk about contracts and agreements. And so while talking about that, I'll be able to answer your question. Thank you for asking. I will definitely answer your question at that point. I hope that.
Okay.
Cool. Do we have any other question, or I can proceed to infringement of copyright? Okay, cool. I will presume that by being silent. Cool. So I think let me proceed. In case there are any questions, feel free to raise your hand and ask. So when we look at infringement, we talked about copyright. You have the right to, like, it's inherent in the word. You have the right to copy that particular piece of work that you've created. Copyright does not protect ideas. The idea has to be put into tangible form. And so when it's put into tangible form, that is when it is protected, right? And so I talked about like the moral rights, the economic rights that subsist in that particular work. And so now we're looking at in what instances can you claim infringement of your work? Yeah, so yeah, let me get into that. So when you look at infringement, there are two forms of infringement. There's primary infringement and secondary infringement. So primary infringement is infringing on the copy of the work. What that is say you have a book, or you have a particular, let's use a book. You have a book, you have not got any consent from the person that created the book. You go and make copies at your printer. Say you at your printer guy at say school or whatever. In that particular instance, you've actually infringed the copyright. You didn't get permission to use that particular work, and you have gone ahead to use that work, right? And make a copy. So that's the primary infringement. And secondary infringement is dealing with the infringing copies by providing premises to do an infringing act or providing an apparatus to make the infringing copies. So in the event someone comes to you, they have a particular book that has been copyrighted, registered, and it's subject to copyright, someone else's copyright. You have your printer and you go ahead and print that particular book. You are a secondary infringer. And because you have created the medium through which the infringement is happening, right? And so that is another way in which infringement can happen. So some of the remedies that would come up in the event you go to court is to account for the profits. If, say, you have this particular notorious printery that has been printing a multitude of copies of your book, and you have, let's say, a limited edition book, and you released only, say, 50 copies of your book. But every time you're walking around town, you realize almost everybody has your book. That would be weird, right? And so in the event that happens, you can ask for an account of the profit. So whatever profits they have derived from that book, you can actually enforce your rights and make sure that they pay you for those for that work. You can have all those copies delivered to you. Yeah, you can ask court to make that possible. You can have a seizure of all those copies and probably destruction of those copies. And then you can also ask for an injunction. So an injunction is a legal remedy that stops them from any further infringement of your copyright. So yeah, that I think details the infringement of copyright. And so the infringement is through the primary and secondary modes. And so yeah, now I can just go to the defenses. So in the event someone drags you to court and they claim that you have infringed on their copyright, what are some of the defenses that you could raise? Or what are some of the defenses that anyone who infringes on your copyright tomorrow will raise and stop you from being able to enforce your copyright? One of them would be authorization or consent. So in the event you have given your consent to someone to use your work, right? If you've given them consent, you cannot then claim infringement of your copyright. Another aspect is for public interest. In the event you have, so under public interest is when some things like security purposes come into place, where you have a particular product that you've come up with and say that particular product is harmful to the community, right? And so someone out of public interest, say, goes ahead and describes your product to these people, or described your book or whatever to these people, they can claim that they did that out of public interest. They were benefiting the public. So public interest is also one of the instances in which someone can raise a defense. The next one is fair dealing. So the use of your copyright or work is considered fair in many jurisdictions. So I think I talked about this a bit, that this can come up. So what happens here is someone uses a portion of your work to do something that they want to do. I think this is rampant on YouTube, where you will find a movie that has been released, and then you'll find, say, a YouTuber or like a music video or whatever, or any YouTube video using a particular portion, let's say like a second or 2 seconds of that movie, right? So that would fall under the fair use exception, where someone will say, I have used only a small part of your work and not a substantial part of your work, so I cannot be infringing your copyright. But that, of course, it depends on the circumstances of your case. And so there are instances in which you can actually be found to be infringing on the copyright. So in the event someone is using your work for research and non-commercial purposes, or private study, or they're criticizing your work, or they're reviewing your work, or reporting current events, that's like news stories. In most cases, you cannot enforce your copyright in those instances. So in the event someone uses 5% of your work for purposes of criticism or review, in most cases, you cannot claim that they have infringed on your copyright. So incidental use or incidental inclusion of your copyright material, say in a film, in a photograph. So if I'm, say, shooting a documentary, and while shooting the documentary, some of your intellectual property work. So if it's a book, I like record your book for a very short period, right? But I've used it either intentionally or accidentally, but I don't intend to infringe on your copyright. What happened is your copyright just happened to be used during that process. That's also one of the defenses, but of course, this is a case-by-case basis. It depends on the circumstances on that case. For educational purposes, like I explained, in case someone is using your work for like their academic work, they're just going to let's say refer to your work. But the most important thing is to realize or understand that your moral rights cannot be derogated. So they would still have to state that you are the creator of that work. And that's why when you look at, let's say, research papers, they will always encourage you to cite the author of that particular work. And if you don't cite the author of that work, that is plagiarism, right? And so that's one way in which your moral rights are enforced through research work. And then in libraries and in archives, so in the event a librarian makes a copy of, let's say, a page or two of your book, and they're using it for non-commercial purposes, that could also be a defense. Yeah. So in Uganda, some of the stakeholders that we're looking at, you're looking at Uganda Registration Services Bureau. If you want to register your copyright, that is where you would have to go to. Uganda Police. So Uganda Police is more on the enforcement side of protecting your copyright in the event you want to enforce. Let's say you get a court order from court stopping someone from infringing, you would use police or get the assistance of police. The judiciary, how the judiciary is a stakeholder is in the sense that judiciary will help to enforce your rights, or in the event someone has infringed on your rights, that's where you'd enforce your rights. And then you have customs. So customs, which falls under URA, is in the event someone is importing or exporting work that infringes copyright, that's how customs will come into place. We also have collecting societies or CMOs. So collecting societies are essentially societies that come together and these collecting societies bring together artists, and these collecting societies are the ones that would enforce your copyright. So let's say you are, let me see, I think I have an example of collecting societies that particularly fall under, let me see, I hope I can find them. Let's see. Just give me a minute while I try to locate them. Okay. Yeah, so some of the collecting societies that would fall under the audio, visual, and interactive media, you have the Uganda Cinematographers Association, you have the Uganda Film Vendors Association, you have the Film Distributors and Marketers Association, you have the Uganda Film Network, you have Film Club of Uganda, the Association of Film Practitioners Uganda, Uganda Film Producers Association, the Association of Core Film Producers, Association of Film Actors, Sound Authors and Engineers Guild, Screen Actors Guild, Screen Director Guild of Uganda, Western Uganda Film Producers Association, Cinematography and Post-Production Professionals Association, National Association of Film, Video Industries and Operators Trust, Uganda Film Publishers Guild, Film and Video Training Institutions Association, National Association of Broadcasters, the United Video Owners Association. So these are some of the natural cultural forums that have membership, but particularly for people in film. And so some of these associations are the ones that you could use to enforce your economic, your intellectual property rights. in the event you want to enforce them and you don't want to do it as an individual. That's a collective way that you can be able to enforce them. So I think by and large, that is the main discussion in respect to intellectual property and copyright. So I think I had also talked about trademarks. I think trademarks are the other aspect that comes into play when you're looking at intellectual property in film. So when you're looking at intellectual property in film, you're looking at films contain multiple layers of intellectual property, including copyright, which is the scripts, the footage, the music, the choreography, the edits, the posters. So those would be subject to copyright. Neighboring rights are the performers, say the actors, the producers, the broadcasters. Trademarks, you're looking at the film title, the film, the studio logo, the franchise branding. That would be where the trademark falls. Then the contractual rights, the agreements that determine ownership and usage, which is something I'm going to talk about a bit later in the discussion. So these are some of the IP rights that subsist or exist in film. So initially, we're looking at copyright. So copyright protects creative expression, including the script and the screenplay, the film footage, the music and the score, the dialogue, the characters, the story, the choreography, the edits, the graphics, VFX, and gives exclusive rights to produce, distribute, adapt, or license the work. So that is an example of the copyright that subsists particularly in film. The neighboring rights that subsist particularly in film, these are, you're looking at the actors, you're looking at the performers, you're looking at the producers, you're looking at broadcasters. So it also includes rights over the recordings, the broadcasts, and royalties. And then when you're looking at trademarks, you're looking at the film or series titles. So whatever name you come up with, that for the film, that could be registered as a trademark. The studio name and the logos, whatever studio you're working under, the franchise identity. So if it's Fast and Furious, that could be the franchise. And so that particular identity is something that can be protected under trademark. And then you're looking at the contractual rights. If you have the contract, you're looking at contracts can determine ownership more than the law. Yeah. And so essential contracts include the actor's release form, the writer's agreement, the director agreement, the crew work for hire contracts, the co-production and distribution agreements, the music licensing contracts. And so some of the ways that you can protect your IP in film is to register the copyright in the film. So this could be the script, this could be the film, this could be the soundtrack. You're looking at using strong contracts in regards to the cast and the crew, making sure that those contracts particularly capture the intellectual property rights that subsist for whoever is taking part. Trademark valuable names and branding, contract distribution and use of watermarks. That way you're able to brand your particular work in case someone tries to infringe on your copyright. So use AI consent clauses to protect your likeness, and then to register with CMOs for royalties, the collecting management organizations, which, like I said, are ways to collectively enforce your rights, and these can also be ways that you can be able to collect royalties. So royalties are the economic benefit from your work. Then to keep detailed production records for your work, right? So I think that in a nutshell just describes the intellectual property rights that subsist in film, right? And so now what I'm looking at is, let's just have do you have any questions at this point? Are there any questions that we have regarding what I have just discussed? Oh, yes, I see Maggie. Maggie has a question.
Okay,
You
hi
can.
everyone. Yes.
Hello.
Let me take you back on infringement on privacy. So I was asking these street vendors that usually sell books on the streets. So are you sure they have the license to do so? And also we have people who gives us PDFs. They share PDFs, but you have to pay a fee. And also on the issue of photos and everything, can you sue someone? For example, this person is my lover and we have been having some private moments. So when there is a disagreement somewhere, they decide to start posting those pictures. So can I sue them? Yes.
Okay. Thank you, Maggie, for your question. So I think what I can say in regards to the street vendors and these PDFs that are rampant, what I can explain is there is one thing to have the law, and then there's another thing to enforce the law. And one of the issues that we have in Uganda and generally in the world today is the enforcement of those laws. That you will have a particular law. Let me give you a simple example of traffic rules. There are a lot of traffic rules that we all know are not right, but even the people who are supposed to enforce those rules are not actually obeying those rules, right? And so that is what happens with those street vendors and these people who are circulating the PDF files, is that the law does not allow them to do that, and they most definitely don't have licenses to sell those books. But the thing is, if the law is not enforced, and if the people who are supposed to enforce these laws are not actively doing that, then they can go ahead and do it. They can go ahead and infringe on the copyright. And so that's a larger conversation that we can have just about the enforcement of these rights. You get that you can have particular rights, but the thing is, the law is protecting you, the law is protecting your copyright. But first of all, have you registered your copyright? Is it something that is registered? What is important to note is even if it's not registered, your copyright still exists, but it's easier for you to prove ownership if it is registered. And we are going to go briefly into what that looks like. But to answer your question, most of these people are infringing on copyright. But the thing is, the law is only as good as its implementation. And if the law is not implemented, then they are going to continue infringing on those rights, right? On your copyright. And so what we're looking at is the digitalization of everything helps us and also works against us, because what happens is that how it helps us is that you can easily track who exactly is infringing on your copyright, right? But the issue then is it's also making the infringement of copyright ubiquitous. Anybody can infringe on your copyright. And so to answer your question, really, it's just about the implementation and the enforcement of the law, right? If the law is not enforced, if the law is not implemented, it will stay in the law books and it will not be made manifest in our day-to-day life. For the second one, I think it's a case-by-case basis. But like I said, the considerations that you're looking at is, first of all, are you identifiable in that particular picture? Did this person intentionally use your picture? And then are they going to get any commercial gain? Yeah. But what I would see in that particular instance is this person could argue that they had your consent when they were taking that picture. And so that is something that you have to battle with in court, where they claim that since you guys were dating, you gave them the consent to take your pictures, right? And so that would be a defense that they would raise in court. And so it would be up to you to now also prove to court that they did not get your consent. They probably took these pictures when you did not know. So it's a case-by-case basis. And of course, you can enforce your rights, But just because you can go to court does not mean you might get what you want, because these people will go ahead and raise some of these defenses that I talked about, most especially regarding consent. Yeah, that did you consent to them taking these pictures? And if you consented to them taking the picture, yes. However, I think there must be a particular law that talks about it. Must be like the Anti-Pornography Act. And so you would probably not pursue them under this particular law, but you could pursue them under that law. So you would have a higher chance of succeeding under that law than you would here, because I would presume that the first defense that they would raise is you gave them consent to take those pictures. Yeah, so I don't know if that answers your question, Maggie.
Yes, it does, but I have something else that just came into my
Sure.
mind. You
Sure.
have said that in the court they will argue that you gave them consent to take the pictures. So does consent of taking picture equals you posting it to the public?
So that would have, and that's essentially why you go to court, right? That those are some of the questions that court would have to determine. But the thing is, you could have consented to them taking the picture, but you did not consent to them spreading this widely. But like I said, it still goes back to court, and depending on how the lawyer that you get, and depending on the facts of the matter, depending on how they argue it, is when you would probably be able to get, let's say, a remedy in your favor. But like I said, it's a case-by-case basis, right? That you giving them the consent to take your picture is not necessarily you consenting to them sharing your picture widely, right? But that is something that you would have to argue in court, and a judicial officer would have to decide whether you actually gave that consent or not. And so it's kind of a case-by-case basis, and I hope that answers your question. Yeah, but my advice generally is please don't take those pictures because once they take the picture, you do not, in most cases, have control over how it's going to be used in the future. And so instead of you thinking about all this argumentation and like including a lawyer, just like don't take it in the first place, and then you will not have it on the internet. I know it's a bit more complicated than that, but like if you can avoid it, please do, right? It will save you a lot. Yeah, so I think my discussion is now proceeding to aspects in relation to AI. Yeah, so our law, when it was passed, I think the Copyright and Neighboring Rights Act must have been passed about 2012, right? And so at that time, AI was not in existence. It might have been in existence, but not in the form that it is now. And so AI is one of, I think, the ways that people are infringing on people's copyright. And so the question inherent in there is, if you have a particular AI that has created, I think Google has like Veo or something, there's that particular platform that can create videos. If AI has created a particular video or work, does AI then get protection for that work? And so that is a question that we have not yet addressed. And there's, of course, a Copyright and Neighboring Rights Amendment Act, but it has not yet been passed into law. And those are some of the questions that we have now. That in Uganda, and I think generally, AI is not recognized as a person. And because it's not recognized as either a natural or artificial person, so an artificial person is a company, right? And so since AI is not recognized as an artificial or natural person, then AI cannot be the creator of a piece of work. And so because we have that gray area in the law that does not fully address if AI can own the work or not, creates a question as to we have a lot of AI work that's ubiquitous all over. We have like music created by AI, we have movies, videos, whatever. But then the issue that we have is if the law does not provide for AI as a person, and so AI cannot own that particular property or intellectual property, how then can we regard that property, right? So in the event someone used AI to infringe on your work, do you sue the AI? Do you sue the person who created the work? I think you would sue the person who used the AI to create the work because the law is still quiet. And so you would look for the easiest person to sue, and that would be the person who infringed on your work by using AI to infringe on your work, right? But I think the bigger question is we have AI is here to stay. AI is being used by artists all over to complement their creative process. Part of my presentation today, I used AI to do it, right? And so it beckons the moral question of, in the event you have come up with a presentation and you have used AI to come up with that presentation, because you are a natural person or because you are part of a company, you can claim ownership of that work. But AI was involved in the creation of that work. So how are you going to regard that work? How are you going to, isn't it morally wrong for you to claim that you created the work and yet AI assisted you? And so those are some of the questions that I would just like to pose to you, the listeners today. Maybe if you have some questions about that or some views on that, that would be an interesting discussion to have. But one thing I would think is, if you were the one that used a particular AI tool to create the work, then you can then apply for ownership of that work, right? But I think moving forward, AI should be made a party when obtaining the license or obtaining ownership of the work. I think that would be the moral thing to do, and that would be the right thing to do, that you make sure that when you're getting the ownership, you can attribute, just like we talked about the moral rights and how if someone creates the work, their authorship has to be attributed every time that work is used. I would think in the future there's going to come a time where you see a song and you see a human being as one of the creators, and you would see AI, say what, ChatGPT or whatever AI tool you choose to use, right? Or agent you choose to use. I would think that is the direction in which we are going. So you have a co-ownership aspect of both the individual and the individual being you, the person who used the AI, and the AI itself. I think another way that we can approach it is to have work created by AI freely accessible to the public, so that no one is deriving any economic benefit from the work that is created by AI, but that work is available to the public. And I think that would be another solution to this issue that we have, to how do you determine the ownership when AI creates it, by just leaving it open and saying if it has been created by AI, then the public uses it. But of course, some of these suggestions that I have are just some of my suggestions and stuff that I think. But of course, the lawmakers and policymakers will have different ways that they want to go about it. But I would also be interested to hear from the people listening what they think about AI and the ownership of AI. Have you had any of your work like infringed on by AI? What are your thoughts on this AI discussion? In case you have anybody that is interested in this and would like to contribute. Sure, Maggie, you can.
Okay, so one thing I know that at the end of the day, we have to embrace AI because that is where the world is going.
True,
So
true.
AI will replace those people who do not know how to use it. And for me, also as creative, it has been a very important tool, very helping, because I can take as many tasks as possible. And also sometimes when I'm struggling with ideas, it really helps to develop. So you have mentioned something about the AI work being available for the public freely. I agree, but I still disagree because AI
Okay.
requires skills. You don't just use AI anyhow. The person who knows how to use AI can make the most of it. For example, during the time when Kenya was mourning Honorable Raila Odinga, there was a guy who created a photo of him, the sunset photo. It was a very popular photo. And of course, people were using it, but he went ahead and acquired the copyrights for it, and he has a certificate of the same. So because of the work
Interesting.
that he was able to do, in generating the ideas and everything, and it became something popular. Yeah, so I feel like we should really give credits to the person that has done the work, because it takes a lot of time to know how to train the AI or to program it to give it what you want. Those are my thoughts.
Okay, I think I agree with you. I think, like you said, in the event someone has taken, like we were talking about the ingredients or what is required for you to claim that you have created intellectual property, is you took effort, you applied your skill and applied your time to create that particular work. And if you have created that work and put it into tangible form, then you own the copyright to the work, right? However, in this particular instance, I would differentiate it from that example that you gave. So, in that particular example that you gave, I think it's only fair that if this person went ahead and used a particular AI tool to create a particular piece of work, then they can claim ownership of that work. I think my issue then is what happens to the AI? Why isn't the AI given its recognition in the process? Yeah, but the differentiating uh, aspect that I would like to bring up is we are getting to a point where AI will, on its own accord, be able to create work without any human being pushing it or instructing it to create work. And so my question then is, what then happens to that work that is created without any human being's input? Someone would argue that, oh, the programmers or whoever programmed the AI owns that work. But like those are some of the questions that are going to come up in the future. And I think it would be interesting for us to just keep on the lookout and see how some of these things are going to be responded to by the policymakers generally, and also just by the public. How is the public going to respond to what the policymakers think? Yeah, and so yeah, but thank you for your contribution. And I think AI is going to be a very big discussion moving forward. AI is here to stay. And I think as creatives, AI helps us a lot. That you have an idea, you have writer's block, you are failing to build up on the idea. AI can be a way that can help you think or ideate or solve that particular issue. And so, yeah, and so I do agree with you on that. But like I said, in the event AI in its own accord can create work without the human element or the human input, how would we regard that work? Would we regard it as public work? Would someone derive the benefit? As OpenAI, the company, then derive the benefit from that particular work? So those are some of the questions that I just like to pose so that you can think about those. And I'm sure in the public domain, you see some of these discussions come up. You see some of the laws amended to provide for some of these things in regards to AI. So yeah, that was my main discussion in regards to AI. Does anybody else have any other contribution before I move on to the next segment of my discussion? Sure, Maggie.
Okay, so just another contribution. I think I agree with you. If the work is purely done by AI without human effort, then it can be of public domain. Because I watched a documentary whereby I saw AI was trained and majorly also in Kenya. And when I was watching that documentary, those people are going through a lot of mental torture because you have to tell maybe AI, this is blood, this is human, like you're training it. They even need to seek therapy. So with those human effort that have enabled AI to be relevant. So I completely agree. When a time comes when AI will work independently, then let that work be freely available to the public. Yes.
Yeah, sure. I think I agree with you. I just do not know how the policymakers will approach it, but it would be an interesting thing for us to follow and and see what comes of that. Yeah. So I do not know. Yeah. So thank you for contributing. So yeah, I think I can now move on to the next segment of my discussion, being the key questions creatives should ask before signing any agreement. And so we're looking at contracts and agreements. As a creative, you are being commissioned for a particular project. What are some of the things that you need to think about, that you need to put into consideration before you take on that particular project? So one of them, you're looking at who owns the work being created. So in your agreement, is there a particular provision that is specifically talking about that? Is it commissioned work? Have you been paid to create this work? Is there a particular provision in the agreement that talks about this? If you are creating this work and it's your own work, and someone is, let's say, investing money in your project, is it clear who owns the work in the end? Because tomorrow they can come up and claim it was commissioned work and they commissioned you to create the work. So that is a primary consideration that you have to think about uh, when looking at agreements, or before you sign the agreement, or these are some of the questions you need to ask. And you need to look at those provisions, and those provisions need to be clear. I think what I can say going in is there are a lot of artists that lose their work, that have been taken advantage of. Why? Because they are predominantly artists. They enjoy what they're doing, and so they have no consideration whatsoever of the business side of their work. But the thing is, we understand that you love doing the work and you don't really care about the money. But the thing is, you exist in a capitalist society, and in a capitalist society, you have bills to pay, you have needs. Those needs are supposed to be met through the work that you create. And there are a lot of artists that are millionaires and billionaires off of the work they have created. And there are a lot of artists who are suffering. They have particular work that they've created that is in the public domain. People are using that work, but they do not derive any sustenance or any benefit from that work because they were not keen to consider some of these questions at the beginning. This is where I, from a very biased standpoint, would suggest that if you have a lawyer in your friends group, if you have the means, at least reach out to a lawyer, let him look at this document, let him advise you on what each of these provisions mean, because you might be signing off all your rights to the work. And like I told you, that's a defense. In the event you consent and sign all your rights to the work to a third party, you cannot enforce your intellectual property rights tomorrow. So who owns the work? That is a very primary and important consideration. Second is, am I assigning my copyright or licensing it? So assignment is, I'll give you an example. You have a festival that is supposed to happen. You have a playwright that has drafted the particular play that is supposed to be performed. There are particular performers who are going to perform. He can assign a performance right, or he can assign a broadcasting right to whoever, either a performer, a spoken word artist, whoever, to perform that particular piece of work. Licensing is you. So assignment means you have given someone that right. Licensing in most cases is more on the commercial end, where you are still like assignment giving out this right for a particular period of time, and you would have a licensing agreement, and that agreement would stipulate your roles, each of your roles, and what that entails. And so the question that you need to ask yourself is, in this agreement, am I assigning or licensing my rights to this other person? What is the agreement saying about that? How am I protecting those my rights in that respect? Next question is, for how long will the contract be valid? So there are contracts that I've read where someone is signing or assigning their right in ubiquity in for the rest of eternity. Yeah, that's not fair, because if someone is using your work, why shouldn't there be a time cap? If they want to use it for eternity, I would advise have like a royalty agreement where, in the event, let me give you a simple example. You have an ad, let's say an MTN ad, let's say Bosco, right? And you are the one who came up with the idea, you're the one who's going to perform that particular idea. Now, what's going to happen is, what most of these institutions will do is they will try to talk you into, we're going to give you this one-time payment, and artists are taken advantage of in most cases. They'll give you a one-time payment and tell you, we're going to say give you 50 million shillings. But for this 50 million shillings, you're going to assign all your rights to this work, all the economic rights. We can use this work forever. We can use your likeness, your image rights, whatever, for this particular ad forever, right? Now, what I would advise is, as opposed to you doing that for a one-time payment, these guys are going to use this ad and are going to get a whole lot of money from that ad. What I would advise you to do is, can you negotiate a royalty agreement where you agree with them that, as opposed to you paying me this cash sum, this huge one-time cash payment, based on the profits that you make, can you pay me off of the profits that you make? So in the event my likeness is used in each of these ads, and the beauty about the digital age is all these things can be tracked. Easy for you to track how much a particular ad is bringing to a particular user or owner of that ad. If you're able to track that, for every profit that they make, can you get a cut off of that? And if you're able to negotiate an agreement like that, that is how you're able to be rich forever. That you are sleeping in your bed, but while you're sleeping, money is being made, because anytime someone listens to that song, watches that ad, you are getting paid. So that is what I would advise, as opposed to you having a one-time cash payment. But there are instances in which a one-time cash payment would make sense, and they make an offer that makes sense. And this is why, like I said, it's important to have a legal person to, first of all, vet this contract that you're going to sign, and also advise you as to the feasibility of this contract. Is it something that they think is beneficial to you, or you're probably getting hoodwinked? Next, will you receive royalties or a one-time payment? I think this, I have talked about it. Are you going to just have a one-time payment, or are you going to get royalties? Royalties are like what I explained. Every time there are profits, you keep getting money off of those profits. I would suggest you go for a royalty agreement. Of course, most of the people you're negotiating with have the upper hand, and they could be, say, a telecom company like MTN or Coca-Cola or whatever, and you feel like you do not have the upper hand. But if you have legal representation, if you have a third party representing you, it's easier for you to negotiate an arrangement that is beneficial to you. Sometimes they will throw a random figure at you, and you will think that figure is considerate, that figure captures your value, but you'll be very surprised that you meet someone who will tell you, I don't think you got a good deal. this is how much these people are making, and you are getting cheated. And so just going and understanding the business aspect of your trade as an artist is important if you want to survive and if you want to thrive off of your work. If you are choosing to take the, oh, I'm a creative, I don't care about the money, that could be a personal choice, but ultimately we survive, we exist in a capitalist society, and in a capitalist society, you have to be able to buy or pay for like the simplicities of life. You want to take a soda, you want to watch a movie, you want to create a movie yourself, you need capital, you need money to do that. So those are some of the considerations that you look at. How will my credit be listed? In case you're to be credited, how would that appear? Are you actually going to be accredited for the work that you have participated in? Is it clear that you're accredited at the end of the project? Can that appear? And then you're looking at, can the producer or organization use my image or voice beyond this project? That's also important. We talked about image rights, yeah, and personality rights. If they use your likeness in a particular ad, can they use your likeness in perpetuity forever? Yeah. So is your contract very specific about that? And does it limit to just that project that they're paying you for? If you do not pay attention to that, they can actually be able to use your likeness forever. Yeah. And this also happens to people who are dead. Say someone like Michael Jackson. There are so many artists that even posthumously, after they are dead, people are benefiting off of their likeness. And why is that? Is because at the time that they were signing these agreements, they did not take the time to understand what the agreement was talking about. So that is also an important aspect to consider. Another aspect to consider is, if volunteering, is there a written agreement outlining expectations and rights? So in most cases, when people are volunteering, they leave everything to chance. They're like, oh, I'm volunteering. It's not important what happens. But you, even as a volunteer, need to be clear as to, in the event this thing you're volunteering in makes money at some point, can you benefit from that? What are your image rights in respect to that particular piece of work? Can they use your image rights in perpetuity? Those are some of the things. So just because you're volunteering doesn't mean you don't have a contract in place. And if there is a contract in place, what are your expectations? What are your rights? So that's something that you also have to put into consideration. So will my role create any proprietary contribution? So acting, improvisation, choreography. Like I told you, intellectual property rights, copyright, there are so many forms of intellectual property rights. So these could be the primary intellectual property rights or the neighboring rights. Like you as an actor, you have rights. You as a producer, you have rights. You as the broadcaster, you have rights. So what happens is, in case you're participating in the creation of a particular project and you probably have a neighboring right, how is that particular right going to be handled, right? And how are you protected in the event of that? And so that's also another aspect that you have to pay attention to. So what happens in case the project is shelved or never released? So you have this particular project, you put your blood, sweat, and tears into it, and the company you're working with just chooses to shelve it and never publish it. What did the agreement say about that? Is there a particular provision in the agreement that provides for that? And so these are some of the important considerations that you have to look at. Another consideration I would advise you to look at is, in the event of dispute resolution, how are you going to approach that? Are you going to go for a conventional dispute resolution mechanism, which is go to court, which is a very adversarial method? Are you going to look at alternate dispute resolution methods like arbitration, which are in most cases cheaper. So you can go for arbitration, you can go for mediation, you can go for reconciliation. So these are alternate methods to resolve your dispute. And so your dispute could be in respect to all the things that I talked about. Your image rights, in the event they choose to shelve your project, all that, you need to make sure that there is a provision in respect to that. Another provision that is important that you would have to pay attention to is a force, I think, majeure, or an act of God provision, which says in the event, let's say, you are stopped or you're not able to perform, or let's say you're a musician, right? You have been contracted to sing on a particular project, and then for some reason you lose your voice. Yeah. What happens in that instance? And so that's when the act of God aspect comes into play, where you have a particular provision that provides that if something happens that is beyond my control, I am not then obligated to go ahead and have to continue to do something that I cannot do, right? And so those are some of the important considerations that you have to look at in regards to if you're before signing or before concluding on any contract. So do you have any questions at this point in respect to the agreements and going about those? Sure, Maggie.
Me. Can you hear me?
Yes, I can hear you.
Just remembered when we were beginning, you talked about duet, whereby we have more than one artist, right?
Yes.
Yeah. So in the event where, because what I know is that when it comes to music, even if a person dies, it will be they still have it's, how do I say it? It's still their property up to 50 years. Then afterwards, it
Yes.
becomes a public domain.
Yeah, and public.
So, point of death, and this is a duet. People don't die at the same time. So how do they go about it? And also, I've heard that your family members or people that you trust can inherit the royalties after you. So in such event, how do they divide, or what happens thereafter?
Okay, that's a very good question. So what happens is there is a whole other aspect that is called, let's say, family. I don't think it's family planning, but estate planning, right? That in most cases, if you are alive, you own rights to, let's say, your house, your car, you have a particular bank account. So what then happens is in the event you pass on, this property is supposed to pass on to your descendants and your dependents. And so that's where estate planning comes into play, where you will have, if you were alive to this particular fact while you are alive, you would make sure that you have a will. Yes. And in this particular will would describe what would happen to all your property, how your property is supposed to be distributed among your descendants, to whom that property is supposed to be distributed to, right? So those are some of the things that would happen. In the event you pass on and you did not have a will, what happens is you go into aspects of administration, where your family has to appoint an administrator, and that administrator would be the one to make sure that there is distribution of your property, right? And so this is a whole different legal process. So what then happens is, if you own the copyright to a particular song, that right supersedes your death, right? So when you die, that right doesn't stop there, it supersedes your death. So what then happens is your estate can then be able to inherit your right, your estate being your dependents, and then your estate can determine how that particular property is distributed amongst your descendants, or if there are any profits whatsoever, how you would go about that. So that is what happens, where in case you have a will, that will is clear as to how you're going to distribute your property in the event of your death, which is something I advise people to do. You don't have to wait for you to be 60. I'm sure each of us here has assets of some sort. You have a laptop, you have a phone, whatever. But of course, I mean, some people would not be happy to only bequeath their phone to their descendants. And so that's why most young people do not have like a will. So the thing is, but as you get older, as you continue acquiring property and acquiring assets, you need to think about what happens in the event of my death. And so in order to answer your question, that's what happens. In the event you have a will, that will would prescribe who gets the property and how that property is divided. In the event you don't have a will, it goes into administration. Your family appoints an administrator. That administrator is supposed to distribute that property amongst your descendants, right? I hope that answers your question. I don't know if I've answered your question, Maggie.
Yes, just to get clarity, or
Yes.
the dual part, right? So how will they start counting those 50 years after, assuming, is it after the death of the last person who produced the song?
So my understanding is, so I need to read up on this in detail, but I'll just give you my opinion right now. But it's subject to, I need to read up on it, because what I know is that you are co-owners in that particular property. So in most cases, when you're looking at land, in case there's co-ownership, there's a principle of survivorship where that particular land would now go, and the person, the surviving owner, would be the one to take the full ownership. But I would think that in the event you have a will and you have prescribed how this particular property would be passed on, you can still be able to pass on this property to your family, to your estate, because you created that property. So the thing is, what happens is, I think to make it a bit more practical, is you create a song, you're deriving royalties off of that song. So let's say every time the song is performed, they are paying you, let's say, 50,000 Ugandan shillings, right? So what happens is, if they're paying you 50,000 Ugandan shillings, the presumption is that, putting all these other aspects aside, tax and the like, each of you is getting, say, 25,000, yeah, from the royalty from like your song, right? So in the event you pass on, your estate can still be able to receive that 25,000 shillings. So, but like I said, I need to read up more on it, but that's my current understanding on how you'd be able to go about it, because a property right is like a right, like any other right. Like if you own the house, if you own the car, right? And so even if it's a song, how you would be able to distinguish the rights in that song is through the royalties, and whatever quantum of the royalties is. If it's 50,000, like I said, you can split it both ways, so that it's like 25,000, each of you is benefiting that way. Yeah.
Okay, so lastly, what happens
Yeah.
to, for example, church organizations where we have members producing their own songs, like singing in bands or choir? Yes. How do they go about it? The law part of it on the royalties.
So where this discussion started, we talked about the aspect of commissioned work. And in most cases, when you're looking at commissioned work, you're looking at, in the creation of this particular piece of work that you've created, did you do it on your own accord? Or if you are working or performing under a different organization, say a church, yeah, the church is providing the equipment, you are producing this song during church time, or you are affiliated to this church. This church has control over you. They're telling you which type of songs to create. They should be Christian songs, etc. So in most cases, that would be commissioned work, and that the church would be able to own the work. And that's why we come back to this discussion that before you even start thinking of creating the song or whatever, you need to have an agreement in place with the church where you clearly stipulate what happens after or what happens in the event the song is created. What do you own? What does the church own? What is the church's contribution? What is your contribution? If there is a sharing of profits, how would that look like? So the importance of this whole discussion is for you to understand that, so that you are not just creating because you can, but you're understanding that for the work that I'm creating, there's a commercial aspect of it. And I also have to be alive to that commercial aspect, and I have to protect myself in respect to that commercial aspect. So I don't know if that helps answer your question. Sure. Do we have any other questions? Okay, cool. I think I can go ahead to the next segment of my discussion. We're looking at key considerations for filmmakers, for actors, performers, the usage of your image and likeness and voice. So these are some of the considerations that you in film and screen creatives, these are some of the considerations you have to look at depending on your role. If you're an actor or performer, how are they going to use your image and likeness and voice? What is the duration of the rights that you have granted these people or organization or whatever? And whether improvisations can qualify as co-ownership. So they say there's a script and you're supposed to regurgitate what's on the script, and you improvise, you come up with something new. How would you regard that particular improvisation? Is it yours because you created it? Is it does the company that has commissioned you own it? And these are some of the considerations you're looking at while you're having the agreement drafted, before you even start. And I think if I'm to emphasize, I will emphasize this again. Before you start, make sure that your rights are protected. Make sure that you have an understanding of what is going to happen in the future. The mistake artists make is they get so caught up in the art and forget the business aspect. And so tomorrow, when their song that they never thought was going to make it, their movie that they never thought was going to make it, becomes big and is earning a lot of money, they realize it's too late because they never had any discussions as to how they were going to be remunerated, who owns the work, how does that look like, what is the duration of the ownership, that kind of thing. So for script writers, you're looking at what the ownership after commissioning, you're looking at adaptation rights. Is this work going to be adapted into a book or a film? Is that in the contract that you have with, say, if you're working with a studio, or if you have investors, if you're an independent an indie film creator, and you have an investor that is investing, and they are talking about adaptation of your movie or your script into a book or a film, what does that look like? Do you still get paid? Then payment for rewrites, that's also something that you have to put into consideration. Then for directors and producers, you're looking at joint authorship issues. Like I said, there are different owners or co-owners in the work. And so if you have multiple, let's say, directors, multiple producers, if you have actors who also have neighboring rights, if you're looking at all those aspects, how are you accounting for all those different aspects? How are these people going to be remunerated? How are you going to share from the profits? Then contracts with the crew and volunteers, like I talked about this earlier, You have volunteers who are taking part. You have the crew that is taking part. Do you have contracts with them? Are those contracts airtight? Are you protecting yourself, or are these people protected? If you are part of the crew, if you are the volunteer, are you protected in respect to your image rights, in respect to your remuneration, in respect to co-authorship in case you come up with something novel? Yeah, then you're looking at rights to edit, distribute, and archive footage. That's also something that is important. Do you have rights to that? Do you have rights to edit the work in case the creative freedom? Do you have creative freedom? Do you have rights to determine how you distribute this work? Are you going to use like Netflix? Are you going to use YouTube? How are you going to go about that? Is this something that you have talked about at the beginning? And is this something that you've considered from the beginning? How are you going to archive the footage? Is it going to be digital? Do you want to have it on tape? Do you want to have it on like a hard disk somewhere? Stuff like that. So those are some of the considerations you're looking at. So for the crew and volunteers, you're looking at even unpaid work grants you rights unless waived. So even if it's unpaid work, you still have rights. So are you making sure that those rights are protected? And do you have clear agreements to avoid future disputes? So that is the importance of the agreement, to avoid any future disputes. In the event you have a future dispute, how are you accounting for it from the beginning? And that's the purpose of an agreement. That's the purpose of a contract, that we as lawyers have been around long enough to anticipate that, okay, because these two parties are going to contract, these are some of the issues that have come up time and again. And so the purpose of a contract is we are accounting for each of these issues and coming up for solutions in the event each of these issues comes up, right? And how we would solve those issues in case they arise. Now, if you are artists and you're working in exclusion of any legal person or any person who has an understanding of all these aspects, you're going to keep running into walls, you're going to keep running into disagreements because you have not anticipated a lot of these things. And when they happen, you guys are at loggerheads, you guys are bumping heads. Why? Because you didn't think about this at the beginning. And so, yeah, there is also a habit of people going to ChatGPT or an AI, and the AI will just like regurgitate some generic agreement, and then they will sign that agreement. But most of those agreements are not foolproof. They are not actually protecting you, right? And that's why it's important for you to have a legal eye. Even if you're not employing a lawyer fully, you could just have a lawyer look through your contract and just let you know that, okay, this is good, this is bad, think of this, think of that, that kind of thing. And so that is a very important consideration at the beginning. And I emphasize this, at the beginning is when you need to have these discussions, not wait for after, because after you don't have leverage, after you have already created it, after there are so many moving parts. But before you have control, you have leverage, you are the creator, you are the one going to make everything possible. And so if you do not choose to protect yourself in the beginning, it will definitely harm you in the future. Yeah. So I see a question: is it advisable to sign a contract agreement before you sign a non-disclosure agreement, which may have a clause that could count any other agreement void in tiny writing? Yeah, the purpose of an NDA, of a non-disclosure agreement, is whatever information you're going to receive, it's privileged information, it's confidential information. So in case you are contracting with another party, you are the playwright, you're the screenwriter, you've come up with your script, you want someone to help turn it into a film. Before you sign any contract, before you give them your script, have an NDA, because what the NDA is doing, it's protecting them and it's protecting this information and keeping it confidential, right? So my advice is sign the NDA before you sign the contract. The NDA should precede or should come before the actual contract, because what you are doing is you're offering valuable information, which is, say, your script, your idea, or your idea put in tangible form to this third party, and this third party can use it any way they like. But what the NDA does is it protects that information, makes it confidential. They cannot share it with any third parties. And then this agreement is a continuation of the NDA, that you have protected the confidentiality of your agreement, and then now you have gone ahead to make sure that you provide for all these other considerations that I talked about, and that would then be in the agreement. So I hope, Mr. Joel, that answers your question. Yeah, sure. So do we have any other questions? I see there was a question in the group chat regarding what licensing terms do you think creatives ignore and end up regretting. I talked about some of those. I could maybe just run through them a bit. And these are the things that a creative should ask before signing any agreement. Who owns the work being created? Is it commissioned work? How are you approaching that? Second, am I assigning my copyright or licensing it? If you have the copyright, is this agreement a form of assignment? Are you assigning this right to someone else? Are you licensing it? If you are, what is the consideration? Are you getting paid for this assignment or licensing that you're doing? For how long is the contract valid? Do not sign a contract where you have a contract in perpetuity. These people own your intellectual property in perpetuity. So even after you die, your children can never benefit. So you need to be very clear about what the period is that you are contracting. Will I receive royalties or a one-time payment? Like I explained, that in most cases, most of these entities are looking at one-time payments. Why? Because it makes financial sense for them to pay you once. However, if they are going to continue deriving economic benefit from whatever piece of work you're sharing with them, you need to make sure you're getting royalties off of that, because that's how you get to have generational wealth, and you get to get benefit, economic benefit from your work, because that one-time payment in most cases does not equate the value that they're going to get from this particular work that you are giving to them. How will my credit be listed? In the event you are the one who created the work, will you be accredited? How does that look like? They should accredit you because you have the more rights to the work. There should be accreditation. Can the producer or organization use my image or voice beyond this project? That is something we had discussed. Your image rights, your personality rights beyond the project. Are you assigning or giving these people the right to use your likeness, your picture in any future projects? One of the examples I gave is the artists who, even posthumously, after they're dead, people are still releasing albums under their name. But the thing is, you will find that their estate, their family is not benefiting from this. It's some record label that is benefiting from this. So if you do not think about that from the onset, you need to also account for that. That's something that you need to think about in the agreement. If you're volunteering, is there a written agreement outlining your expectations and rights? That's very important. What are you doing about that? How are you protecting that? Will my role create any proprietary contribution? If you're acting, improvising, choreography, whatever, how is that going to be handled? Whatever proprietary rights that arise, like I talked about the neighboring rights as an actor, as a producer, etc. How is that going to be handled? What happens if the project is shelved or never released? You have put your blood, sweat, and tears into the project. These guys choose that they're not going to release it. What happens in that particular instance? Some of the other aspects I talked about is a dispute resolution clause, and then what else? I'm also looking at a force majeure or act of God clause. In the event you are prevented beyond your control to deliver, you should not be forced to deliver. There has to be a clause that protects you in that regard. And so I think those are some of the considerations I would look at. And unless someone has any questions, I think I've come to the end of my presentation. Yeah, thank you. I see oil. Oh, there are a couple of questions. What are the limitations of a copyright certificate if I copyright my script in Kenya, but I did the task remotely and it was an international partnership with someone outside the continent? Does my copyright certificate still hold strength against infringement? There was no contractual agreement, but the script label was done. Okay, I'm seeing so many questions in here. So what are the limitations of a copyright certificate? I think the limitations of a copyright certificate to begin with are, like I said, there are limitations or exclusions to your rights to your copyright. Those being in the event someone is using your work for educational purposes, in the event of fair use where they're using part of your work and not the full part and not the full work, in the event, let's see, what are some of the other aspects? In the event they are using it for criticism or public policy or public aspects come into play, in the event of, like I think I already talked about educational purposes, in the event you authorize them to use the work. So those are some of the limitations. So the general limitations to copyright would be the limitation to your copyright certificate. If I copyright my script in Kenya, but I did the task remotely, I do not know where you are, and it was an international partnership with someone outside the continent, does my copyright certificate still hold strength against infringement? I would think the copyright certificate would capture both the co-authors in that particular work. So I think if you have approached it the right way, if you've made sure whoever owns their copyright has been given, attributed their role, and the copyright certificate cannot be challenged by, say, one of the co-authors, I would think it still holds strength because that's its purpose. That's the copyright agreement is supposed to protect your copyright. But I think based on one of the questions that Maggie asked also in this respect is, what you also have to know is that the law is in place, but the implementation of the law is sometimes not in place. And so you might have a copyright certificate, but it's almost impossible to enforce your copyright because of the digital methods of infringement and all these other like ubiquitous ways that people can infringe. So I think that those are some of the things that would come into play. And so if there was no contractual agreement, but the script label was done and the copyright certificate gained, can one ask for emoluments for work done? I would think, how would you ask for payment if there was no contract? I think that's the question. Like, how are you determining how you would get paid? How I would think about it is, in the event this third party is getting particular profits and you're able to know how much they're profiting, then you could claim off of that profit for a cut for yourself. But if you proceed without a contract from the onset, you're putting yourself at a disadvantage, because without a contract, you're leaving it to the interpretation of court, you're leaving it to the interpretation of whoever you go to, either an arbitrator, mediator, whoever you go to is going to determine what you're paid and what your contribution is. And they can actually also claim that this was commissioned work and you still do not get paid in the end. So I hope, Joel, that helps to answer some of your questions. And if you have any, if it's not clear, you can still ask. Okay. Do we have any other questions? Oh, Maggie. Sure.
Yes, so I don't know if it's a question or I just need maybe an advice. You see, I was doing film, and one of our trainers shared their experience with working with an international company. So she was hired as a producer for a film here in Africa. So during the process, because she was doing a lot, taking them to the locations and ensuring everything is okay, so they sent her the contract, and then she did not like the terms. They had even written the amount, but according to her, she saw that this is a project that has great potential. So I think she needed more, maybe to do also with accreditation and so on. So
Yeah.
when she refused to sign the document, they just kept quiet, and the project went on. So what they did, they just sent her the money as it was written in the project. Then afterwards, when the film went on and it did well, they sent her a link to watch the film, but as a view once. So she cannot even use it. She didn't get to see it more, and even when she searches it, she can't find the film. Yes. So what do we
Yeah,
do?
so
No. Okay.
I would think in this particular instance, that's unfortunate what happened to her, right? But that is the reality of the space that we work in. That we have big players and we have individuals, and what then happens is the big players are able to bulldoze or take advantage of the individuals. My advice would be in a couple of respects. First of all, if she was talking to them as an individual, it's hard. If she has legal representation, it's easier because then her lawyer is able to talk to their legal team and they're able to hash out an agreement. Yes. So that is one way that she could have approached it. The second way she could have approached it is, remember that long list of associations that I talked about? Yeah, there's a very long list of associations in Uganda of like film guilds and whatever, and associations of just bringing together artists. And so in that particular instance, she can they can approach her through the association, or she can use the collective voice of an association to talk to that particular entity. Because if she goes to that entity as an individual, she has no leverage. If it's Netflix or whatever, like you as an individual have no leverage. But if you come together as, let's say, film producers in Uganda, and so when you have this particular project, you are a member of that association. And so for you to do business, they have to talk to you through the association. That's one way that you can actually be able to gain more leverage as a creator. But the thing is, what they did was not professional. But that is a reality. Yeah, in the event that she kept quiet, but she continued to do the work. And so in the law, in most cases, if you continue to do the work, yes, even if you keep quiet and you continue to do the work, it's presumed that you have accepted the terms that they suggested. You understand? Because they sent you a contract, you saw what the contract said, and you continue to show up every single day. And so if you continue to show up, you have accepted the terms of that contract. And so that's why they sent her the money that they did. Of course, she could choose to take them to court, but she would not have a very good case. Yeah. And so for me, what I'm thinking is, if you go as an individual, it's harder. If you have legal representation, I, as a legal person, can be able to talk to the legal team of that entity or that production house or that movie studio, whatever it is. I can hash out a better deal than one that you would come up with as an individual. That's one. Second, use the collective effort. You have producers, associations of producers, work with some of these entities under those associations. Yes, and so when you're able to do that as a collective, it's easier for you to have leverage and negotiate better terms for yourself. Yeah, so I hope that gives some guidance in respect to that particular issue.
Yes, so in her case, I think because she involved a lawyer, that's why she was able to know that the terms in the contract were not okay. But I think she
Yes.
lacked the association and also that excitement. It was her first. She was young, and then they were her first international client, so they didn't. You know, when as a creative, I get maybe a big client, I will not be so petty on things because I trust them and I know they will deliver. So I think that was
Yeah.
the issue, but I've also learned. Yes.
Yeah, I understand that, and this is the challenge that we as lawyers face is you get a client and you have their best interests at heart, but they are emotional or passionate, and they choose not to consider your good faith like advice. You have told them something that you know, and they in the depth of their heart know you're telling them the truth, but because of their passion, because of all this, they choose to go down a particular route. But the issue is, and I kept saying this, that beyond being a creative, you are surviving in a capitalist world. These institutions are making so much money off of these projects. You have the talent. You need to be able to level the playing field. You need to, if you can't level the playing field, do everything within your power to level it and benefit from your work. But the thing is, you will see your work out there, people will receive accolades, people will receive paychecks, people will get rich off of your work, and all you are is bitter, right? Which is not something that we want. And so that's the purpose of these spaces. That's the purpose of those associations. That's the purpose of us as lawyers to assist you. That you can find in that particular instance, the lawyer told her that this is not a very good deal, don't take it on, but she's excited. This is, and because of that excitement, she continues against the lawyer's advice, but she suffers because of it. And so, yeah, that's what I think. It's unfortunate what happened, but I'm sure moving forward, there are other ways that you can be able to circumvent such issues based on, what has happened to people who have come before you. Yeah. I can see they're reminding us about time. So if we have maybe one final question, you can ask, and then we can end the session. Okay, I think we could end the session. I don't see any questions.
Okay. Is there anyone who wanted to ask a question? I think like our time is already past for 37 minutes. But Bright, Emmanuel, so I honestly don't even know where to start. Thank you so much for the amazing session today. I think we learned so much, not just about protecting our ideas, but also, well, maybe how to protect our luck from bad vibes. I'm just kidding. Okay, but seriously, the way you explained IP made it feel like so simple, clear, and also I know intellectual property can be complicated more than that you explained, especially with different rules and regulation in different countries that we have. But you made it feel like something we can actually understand and use it in our real life. So I wanted to say I'm glad that we have you. I was even telling my sitcom writer and director, the one that I'm starting to produce next month, to listen to this session so that they know their rights and they won't end up empty-handed at the end of the day because of me. That's how important and practical your advice is. So, in the examples of that you shared earlier at the beginning, like the party picture being used on commercial, that was the real story. And I was laughing like behind the scene. because it's true. But also it's really his home, how important is for all of us knowing our rights and protect our works. So that's a lesson that's priceless for anyone in the creative field. And we are just filmmakers, right? And I also loved the way how you have made everything so mutual for all of us and easy to understand. So you didn't just teach us the law, you showed us how to apply in real and practical ways, especially about the AI thing, the commercial, how to like for commission works, contract, and other things we didn't focus most of the time, but that's a huge for filmmakers, writers, all creatives actually. So thank you so much for that, for your passion. And like I think my both parents, my father and my mother, is a lawyer. So I think like it doesn't mean you are boring. They are boring, but you are not. Well, yeah, you teach us how to protect what we love, what we have worked hard for what give us joy. So that's everyone who wanted to know. So on behalf of entire Film Chat family, I just want to say thank you. Thank you for your time. Thank you for your patience. Thank you for your knowledge. Thank you for your humor. Thank you for your incredible ability to make us feel learn from you. We hope this is just the first time of many sessions with you. So Emmanuel, thank you. So I just wanted to ask Maggie, the one and only who was asking and enjoying this session. I hope I will create another session for you only. Maggie, thank you. Like you give for this session a life. So Maggie, can I ask you to pray for us before we are ending this session?
Yeah, sure. So thank you so much, Emmanuel. Quite an insight. I've learned a lot. Yeah, and thank you for Film Chat for making it possible. May God bless you. Yeah, so let's bow our heads for a word of prayer. Father, Lord, in the name of Jesus, Lord, we thank you so much for this session, Lord. We have heard you've been taught a lot, Father, and right now we are aware, Lord, we are no longer living in darkness in terms of our career. So we thank you for this opportunity, and I pray that each and every one of us, whatever it is that you have been able to take from the meeting, may we now go out there and implement the meeting. Thank you for Mr. Emmanuel. I pray that you'll continue to bless him for volunteering to give us this wonderful word, this wonderful knowledge. I pray, my Father, that you will continue to meet all his needs according to your riches in glory, and also for the Film Church fraternity for making it a success. May you continue to bless them and continue to open the doors. As we sleep tonight, may you take good care of us, Lord. I pray that we may also wake up tomorrow energized and ready to implement every single lesson that we have learned tonight. It is in Jesus' name I do pray, trusting and believing. Amen.
Amen. Emmanuel, thank you so much. And I hope all of the Film Chat already enjoyed the session. We can find it on YouTube. So yeah, let's share for the creatives who needs to hear about this. So thank you. Have a good night. We see you next week. Bye bye.